The legal writing program in the first year is unique for being conducted around topics that are selected by individual professors. So these are often areas of our scholarly interest, and in particular in my class, for example, I teach privacy law with an emphasis on how privacy and technology interact. We assign 3 writing assignments, and we find that students' interest, which cribs off of the professor's interest in the subject matter, translates in a nice way into learning the mechanics of writing. They gain a degree of autonomy and ownership over their writing in the class by having felt that at the front end they selected a topic that was of interest to them. I build a strong foundation in the first assignment, which is designed to encourage students to learn the technique of self-editing. So I focus on clarity, discipline in writing and editing, linearity, logical flow, all important things for writing of any type.
I'm having a hard time buying the false light argument.
Well, I mean, maybe the fact that she's in the middle of a performance saying that, well, how about this one where she says, my God, I only did the ballet the first time, like 2 days before we went on the stage. And the company is selling tickets, right? So the second assignment drills down more to a specific kind of legal writing. They write a memo to me, and I'm positioned as a justice in the Supreme Court. So they write objectively. They sort of weigh out both sides of an issue as though they had been presented to us, the judge and the clerk. And then in the last assignment, they have to actually operationalize, so the top of the pyramid. So they respond to a complaint. One side of the class files a motion to dismiss the complaint, and the other side files a motion to oppose the motion to dismiss. So this takes sort of the capstone moment and gives them a little bit of a push at the end of the semester to do something argumentative, to really take a side and argue as forcefully as they can, which is, of course, what we do as lawyers out in the wider world.
I would say that in relation to the CODIS database, they would argue strongly that there's too much prone for error and abuse. There's too many people that have access to the data.
Who would argue? Who's
that the police officers would argue.
Sure.
That they don't have they don't have the correct procedures in place.
Right. You know, the legal writing program at Vermont Law School is carried out over the course of 3 semesters. It's also tied very closely to doctrinal teaching. So there's a carryover into, for example, writing and issue spotting, and to carry those 2 activities on in lockstep over the first 3 semesters of law school really works for the students to feel that they get an immersion experience in the first year, but one that is not overwhelmingly so. They get a lot of guidance, and I think it carries over nicely into their success in the doctrinal courses.
Objectives. You can say that maybe they could achieve the objectives, but the things that we were talking about last time about the communal password.
Teaching is a real pleasure. It's an opportunity almost every time you teach or meet with a student individually to give them a sense of their greater abilities. And part of that is just transmitting to them the didactic aspects of letting them know how to read a judicial opinion, how to write a memo. But another part is being an authority figure in their lives who's also kind and encouraging. I think particularly being a woman and a minority, that I'm closer to their individual experiences. Teaching is unique in that it's a win-win situation for both of us. I really feel that. It's true.